Happy to meet you all again through this video. In the last GST Council meeting, a lot of changes have been proposed and a lot of notifications have been issued. And the rate of GST applicable for several commodities and services have undergone changes. And out of all the changes, the most important being the rate changes on various food items, that is cereals, pulses, and all, falling under various chapters like chapter 2, 3, 4, 5, and more importantly, chapter 7 and chapter 10. Various cereals and pulses. There has been a change in the rate of GST applicable for them, which has created a lot of confusion and a lot of anxiety among the trade. And in this video, we will try to understand the changes. From 1st July 2017 to 22/9/2017, the tax liability on these items, that is mostly cereals and pulses and all, it was like this. If those goods are sold under a registered brand name, it will be liable to GST at the rate of 5%. And in all other cases, it will be exempted from GST. This was the position. So what happened? As we all know, under the Trademarks Act, the registration of a brand name is not compulsory. The registration will give some better protection. That's all. Even an unregistered brand name, that also ownership can be claimed by long use and all. So after this GST introduction, when all the registered brand name products are attracting 5% GST, people started deregistering. That is, they surrendered the registration of the brand name and started selling under the unbranded items without any brand name or unbranded, unregistered brand name. So the registration has been surrendered and the brand name becomes unregistered so that they are claiming GST exemption. So then the government made some amendments with effect from 23/9/2017. So they changed the scheme like this. It is not only registered brand name, even if you are using an unregistered brand name, GST will be applicable at the rate of 5%. But if you want to claim exemption, you have to declare that you do not claim any ownership over the brand name which is being used by you. That is, whatever rights I have, the actionable claim I have over the brand name, I have to surrender. For that purpose, I have to file an affidavit with the department. Further, on each and every package, I have to declare that this particular brand name, I don't have any right. It's an open invitation to all the people. Whoever wants to use this brand name, you can use, and I don't claim any ownership over it. It's how far it is ethical to put such a condition just for the sake of giving a GST exemption is rather intriguing. So after this amendment also, a lot of doubts were having, a lot of cases are being booked, and a lot of confusion was going around. And now they have made one more amendment, which is going to come into effect from 18th July 2022. And this brand name has been totally taken away. The requirement of registered brand name, unregistered brand name, filing affidavit, declaration, all those things have been removed. And now it has been made, if those products like the pulses and cereals, if they are sold in a pre-packaged form and if they are labeled, then they will be liable to 5% GST. In all other cases, it will be exempted. So whenever these goods are sold as pre-packaged and labeled, then GST will be applicable. This is a change. So the term pre-packaged and labeled, that is also defined in the notification by making reference to the Legal Metrology Act. So pre-packaged commodity means prepackaged commodity as defined in section 2L of the Legal Metrology Act, where the package in which the commodity is pre-packed or a label securely affixed thereto is required to bear the declarations under the provisions of the LM Act or the rules made thereunder. So this is what the definition under the notification. So we have to go to the provisions of the LM Act, it is the Legal Metrology Act, and under that lot of rules have been framed. And this rules is very important, legal metrology, packaged commodity rules. So these are very important. Basically, this Legal Metrology Act is a Consumer Protection Act. So if you go to a traditional shop where the goods, suppose I go to a shop and I buy rice, the rice will be stored in a big bag If I want 1 kg, the shop owner will measure 1 kg and give it to me. So that packing is happening in my presence. I have the opportunity to check whether the measurement is proper. But in case of prepackaged commodities, the customers may be cheated by unscrupulous elements. So this legal metrology is basically a Consumer Protection Act. Now, under that act, prepackaged commodity is defined as prepackaged commodity means commodity which, without the purchaser being present, is placed in a package of whatever nature, whether sealed or not, so that the product contained therein has a predetermined quantity. This is the definition for the word prepackaged commodity. And section 18 of the act says lot of declarations have to be made on prepackaged commodities. That is section 18. What are those requirements? They are framed under the rules, legal metrology, PC rules. Under these rules, the chapter 2 contains various provisions. Under that, rule 6 to rule 18 talks about various declarations to be made on packages, on the prepackaged commodities packages. Rule 6 to rule 18. What should be the declaration, what it should contain, what should be the size of the label. So all these conditions are spelled out under rule 6 to rule 18. Rule 3 says, under this chapter, rule 3 says, this chapter does not apply to packages containing more than 25 kg or more than 25 liter, cement, fertilizer and agricultural farm produce sold in bags above 50 kg, packages meant for industrial consumer or institutional consumer. So these type of packages are excluded from the coverage of chapter 2. Chapter 2 will not be applicable for these type of packages. So now one of the requirement here is industrial consumer and institutional consumer. These terms are also defined. As I said in the beginning, this Legal Metrology Act is a Consumer Protection Act. So if an industry is buying a raw material, for example, an automobile industry buys various components, screws, bolts, nuts, bearings and all, which are all pre-packed. So legal metrology will not apply because that industry is not treated as a consumer. Consumer means it is only the ultimate consumer, the common man. So the act is meant to protect the interest of the common man. So the provisions of chapter 2 will not apply for the packages which are supplied to industrial consumer and institutional consumer. Institutional consumer, for example, hotel is there, a restaurant is there. So they are buying these food items, pulses, cereals and all. So the requirements under the chapter 2 of LMPC rules will not apply for such packages which are sold to industrial consumer and institutional consumer. Now a question may arise, whenever there is a package of these products of more than 25 kg, say 30 kg, whether I will get GST exemption. That is the most important question which is in the minds of everybody. We will get the answer about it sometime later. Now, this is about chapter 2. Then there is a definition for the phrase wholesale package under rule 2R of the legal metrology packaged commodity rules. A wholesale package means a package containing number of retail packages where such a first mentioned package is intended for sale, distribution or delivery to an intermediary and is not intended for sale direct to a single consumer. Or a commodity sold to an intermediary in bulk to enable such intermediary to sell, distribute or deliver such commodity to the consumer in smaller quantities. Or packages containing 10 or more than 10 retail packages, provided that the retail packages are labeled as required under the rules. So this is wholesale package. Now, suppose rice is packed in 50 kg. Rice is packed in 50 kg. We have seen under rule 3, it says chapter 2 will not be applicable for any packages containing more than 25 kg. But a rice bag of 50 kg, when it is sold to another dealer, who will again be selling that rice in smaller quantities, then the 50 kg rice bag becomes a wholesale package. So when a 50 kg rice package is sold to a hotel, it becomes a supply to an institutional consumer. Legal metrology will not apply, so GST exemption will be applicable. But if same rice is sold in same 50 kg package to another dealer, It will become a wholesale package because the dealer is going to sell it again in smaller quantities. So legal metrology provisions will apply. Chapter 3 will apply. So GST exemption will not apply. So what is chapter 3? Chapter 3 says rule 24. In case of wholesale packages also, certain declarations have to be made. So if the definition of wholesale package, which we have seen in the previous slide, if that is satisfied, there are requirements of certain declarations under rule 24. So it will not get exempted under GST. So just because a package is containing more than 25 kg, we cannot conclude that it is exempted from GST. Still, if it is in the nature of a wholesale package, it is sold to a dealer for subsequent sale in smaller quantities, then the seller of that particular package containing more than 25 kg or 25 liter, they also will be liable to pay GST. This is very, very important, which we have to note. This rule 24 also says, nothing contained in this rule shall apply if similar declarations are required under any other law. Under any other enactment, if there is a requirement of affixing details about the manufacturer and other details, then legal metrology provisions will not apply. So once the legal metrology provisions does not apply, the GST also will not apply. So we have to see if there are any requirement of such declarations under any other law. I'm not able to immediately visualize what all other laws could be there to prescribe various declarations on wholesale packages. We have to see that. So that is one exemption. And rule 26 says, nothing contained in these rules. These rules means the entire rule, chapter 2, chapter 3, everything. So it will not apply if the package is containing less than 10 gram or less than 10 ml. Then agricultural farm produce, if it is sold in more than 50 kg also, these provisions of the entire rules will not be applicable. So more than 50 kg package, agricultural farm produce. Agricultural farm produce means it should be the produce which is obtained from the land without any processing or with minimum processing. So once it is processed, it cannot be considered as an agricultural farm produce. So now, what are the important points which we have to note? A package containing 25 kg or 25 liter or more, it will not automatically be exempted from GST. If it is in the nature of a wholesale package, still legal metrology provisions will be applicable and GST also will be leviable. Whenever any packages, irrespective of the quantity, are sold to industrial consumers and institutional consumers, then the legal metrology provisions will not apply. That the chapter 2 will not apply, but it will not qualify as a wholesale package also, because those industry and institutions, they are not buying it for resale. They are buying it for their own use. So it will not be a wholesale package. So chapter 3 also will not apply and chapter 2 also will not apply. So for any packages, irrespective of the quantity, if they are meant for institutional consumer and industrial consumers, the LM provisions will not apply and GST exemption will apply. And agricultural farm produce sold in packages of above 50 kg, that also will be excluded from LM Act, and consequently it will be exempted from GST also. So these are all certain important basic issues which we have to be aware of about these provisions. Individually, there may be a lot of cases, a lot of doubts. So all those doubts have to be approached on a case-to-case basis. So I have tried to cover the minimum clarity. I tried to give a minimum clarity about these provisions. I hope that this particular video would have been useful for you. Thank you.